Good morning and welcome to oral arguments.
Good morning.
This moment at the Fifth District Court of Appeals. Before I begin, let me introduce the panel. Judge Forfinger to my right, Judge Torpey to my left. My name is Emerson Thompson. I'll be presiding today. We have mixed cases. Procedural matter, we have one case to the beginning of the docket. That's HUDEC versus HUDEC.
HUDEC.
DEC. Thank you, sir.
Yes.
And the others will then proceed in order.
Yes.
Let me finish. After we finish with the Sadler case, we'll take a break, allow the lawyers to refresh themselves, and then there's coffee in the lawyer's lounge. So the civil cases have 20 minutes per side. They have to allow reserved time. Just let me know and I will assist you. And the criminal cases have 15 minutes per side. So this time we'll start with the HUDEC case.
Thank you, Your Honor. I would like to initially thank the court for permitting me to appear first at the 9 a.m. Slot. Henry Martecci on behalf of Suzanne HUDEC in this case. I assume that the members of the panel have read the briefs and studied the record. This is the case where the trial judge granted summary judgment in favor of the insurer on a claim for uninsured, underinsured motorist coverage. And the difficulty is that with regard to summary judgment, the case of Hall versus Talcott in the Supreme Court, while it was a medical malpractice case, is very instructive on the what's required for a summary judgment. The moving party has the burden of conclusively demonstrating the absence of a genuine material fact. And the word conclusive is defined in Rogers Harris as without doubt, beyond all doubts, decisive, being definite, irrefutably final or certain. And in the Hall versus Talcott case, the trial court, which decision was affirmed by the District Court of Appeal.
Mr. Martecci, why don't you tell us what the evidence is? Tell us what the evidence is
In this case.
that supports the inference that your client's decedent was occupying the vehicle.
Okay. The trial judge, in his order on the motion for summary judgment made by the insurer, which is in the record at pages 465-469, and on, I believe, 466, I'm sorry, 467. The trial judge points out at least two possible inferences with regard to whether or not the HUDEC brothers were occupying the insured vehicle with the flatbed trailer on it when they arrived at her home. Her affidavit deposition testimony, according to the order of Judge Jacobus, determines that one inference is that she did not see the vehicle. She said she was standing at the garageway and she could not see her husband's vehicle in any direction, and she had seen he and his brother Ralph, Ronald being deceased, walking together from the car to the insured vehicle to the house.
Mr. Martecci, why is it relevant what vehicle the brothers arrived in? Isn't it relevant whether or not your decedent was occupying an insured vehicle at the time he was killed?
because the policy describes coverage as being limited to either the owner of the car or a member of his household, which Ronald was not, or if you had been a passenger in an insured vehicle or was alighting therefrom. And what the trial judge indicated was there were two inferences with regard to whether or not Ronald had the deceased had ever occupied the insured vehicle. I just told you the one. The other one was that she did not see it because she hadn't looked in the right place. So there's two conflicting inferences. Conflicting inferences of the non-moving party.
Isn't there testimony in the record that they were not in the same car?
Yes. The deposition testimony of Ralph HUDEC. However, Ronald is not here now to dispute that. So whereas appellee, State Farm, states that Suzanne HUDEC's affidavit is self-serving, it is actually the testimony of Ralph HUDEC, which is self-serving.
Well, Mr. Martacci, Judge Jacobus made a finding in his order that said even if we assume that your client...
I was about to get to that.
...rode over to the premises with his brother, at the time of the accident, he was, as I understand what Judge Jacobus found from the evidence, at the time he was struck, he was standing, and they had unloaded a mattress from the trailer. He had gone out into the street and was apparently directing his brother how to back up the trailer.
That is correct.
When a car comes along and...
That is correct. I was about to explain that, Your Honor. I'm sorry. You beat me to it. There are a lot of cases from Florida, which is Tanchuk, citing Day versus Coca-Cola from Louisiana. There is the Olson case from Nebraska. There is the Century Insurance versus Washington Insurance Company from Wisconsin. There are all sorts of cases indicating that there is a zone of risk. In the Olson case, a 15-year-old was driving a car owned by his parents. You had a 16-year-old friend. They had apparently rolled the car over, but both of them crawled out and apparently were all okay. Both were okay. Later, within a few minutes, the 16-year-old touched a power line and was electrocuted. The appellate court reversed the trial court and found that that 16-year-old was within the zone of risk. He had not completed alighting from the vehicle. Tanchuk, citing Day versus Coca-Cola, indicates that the test is the proximity of the injured party to the vehicle, the insured vehicle, in time and distance. Obviously, I cite Allstate versus Thomas. Appellee cites Allstate versus Thomas. I cite it in order to distinguish it. If a person gets out of the insured vehicle and walks across the street to his or her home, obviously they no longer have any contact with the vehicle. The case law also states that in order for the termination of alighting to take place, the injured party must have ceased all contact with the vehicle. In this case, Ronald HUDEC was directing his brother out of the driveway. They were still involved in the completion of the task, which was to remove one mattress from Ronald HUDEC's present residence, to bring it over to the marital residence where Suzanne was residing, to get a mattress from Suzanne's house and bring it back to his house. Now, they had unloaded the mattress. The two HUDEC brothers gone into Ronald HUDEC's house with the new mattress and come out, and Ronald was directing the brother out of the driveway. He was assisting. He still had contact with the vehicle. He still had contact with the vehicle.
Did he have contact, or are you saying he intended at some point to get back in the vehicle? Contact, I mean, touching.
You don't have to touch the vehicle, you don't have to be touching the vehicle, you don't have to be getting back into the vehicle. You have to have ceased all contact with the vehicle.
Is there a distance in the record how far the brother who was injured was from the flatbed trailer or the car?
Well, he was obviously close enough to be directing the brother out. I don't know how distant he was from the vehicle, but obviously he was in the roadway, fending off the oncoming traffic and motioning his brother out of the driveway in order that they could complete the whole task, which they had agreed to which they had agreed to perform.
Are you arguing we should look at the intent of the person? That is, when they plan to get back in the vehicle, and what they were planning to do subsequent to getting out of the vehicle?
From the case law, I do not see any case which states that the person had to be, after having alighted from the vehicle, had to re-enter the vehicle in order for there to be the coverage. I don't see any case law. I've examined the case law very carefully. And I don't see any such thing. What I see is case law that indicates that the injured party must have ceased all contact with the vehicle, with the insured vehicle. I think I was telling you about Olson.
But let me ask Mr. McCarthy, if you were writing an opinion in this case,
Yes.
case, your argument is that there's no requirement of physical contact.
That's correct.
How would you define, if you were writing the opinion,
Okay.
what would you have us write
Okay.
that would encompass your definition of contact? I'm trying to understand
Okay.
how expansive your view is.
I would say two things, Your Honor. One would be that Ronald HUDEC was within the zone of risk, and the other would be to the effect that Ronald HUDEC had not ceased all contact with the vehicle. Not necessarily touching the vehicle. There are cases where coverage has been afforded on the underinsured motorist coverage where the person was not in close proximity to the vehicle. Take the case of Tanchuk, which involved a tow truck operator who had left the vehicle and gone to assist the motorist who had the accident or who had a flat tire, determined that there were two flats on the Toyota, that was the rolled over car, and went back to the truck in order to call his employer and say, we need a flatbed over here. He had the phone from the car, from his tow truck, and he was talking into that phone. Coverage was afforded. The Tanchuk court, the parties made cross motions for summary. The trial court granted summary judgment in favor of the injured party, stating that there would be coverage, and the I believe it was the 4th District affirmed the trial court's ruling. There is also the point to be considered that all conflicting inferences on summary judgment are determined in favor of the non-moving party. And the moving party is required to rebut in advance of the non-moving party being forced to go forward with anything. To show that any reasonable inference might be raised in favor of the non-moving party.
Mr. Martacci,
Yes.
if I had been walking down the street, I didn't even know the HUDECs. I was walking down the street and I see Mr. HUDEC trying to back out into a busy road. And so, being a good citizen, I voluntarily undertake to direct traffic when I'm struck by the car going down the street. How does my zone of risk differ from your theory for the late Mr. HUDEC?
Because you had never had that driver, you, Your Honor, had never had any contact whatsoever with the insured vehicle. You simply, as a good citizen, was directing traffic, which is an eminently reasonable thing for you to do as a good citizen, but, and laudatory, but,
So your
it doesn't afford coverage under the terms of the policy.
your zone of risk analysis would change, even though Mr. Hudak and I were doing the precise same thing in the exact same location. Somehow he was within the zone of risk, but I was not, because he had arguably ridden over to the house in the car. That's the one distinguishing factor.
Right.
Okay.
No. No, you would never have had any contact whatsoever with the vehicle, with the insured vehicle, Your Honor.
Is there a
Not only being an actual occupant of the vehicle, but you had no contact with it in your simile.
Is there a time that you would say creates a break in the contact? In other words, if they had delivered the mattress, gone into the house, eaten lunch, had something to drink, and then an hour later came out and he's directing traffic, is he still in contact with the vehicle?
Yes.
If he goes in the house, spends the night, and comes out in the morning and directs traffic,
Yes.
he's still.
Yes.
They park the car for 3 weeks and he directs it back out.
Well, perhaps spending a night, that's a little long time, but I would afford coverage because we have also the rule of law to the effect that all inferences are to be indulged in favor of the non-moving party in order to achieve coverage. So that I feel that Judge Jacobus erred in this case, and I believe that upon an examination of the record and the briefs in this cause, that the panel should reverse the judge order of the trial court and send it back for jury trial. There are two questions of fact, at least two questions of fact, which Judge Jacobus resolved. He resolved those two conflicting inferences in favor of the moving party. He resolved the question of fact as to whether or not Ronald Hudek was alighting from the vehicle, and he resolved the two inferences as to whether or not he had arrived at Suzanne's residence in the insured vehicle, both of them.
Do you want to reserve any time?
Yes, I am, right now.
You have 3 minutes left.
3.11.
Good morning. May it please the court, Matthew Haftel here on behalf of State Farm Mutual Automobile Insurance Company. Judge Thompson, I'd just like to address a question you had.
Well, let me ask you a question.
Okay.
The two brothers left Suzanne's house, and then went to another house right before the accident. Is that right?
The brothers brought a mattress over to Suzanne's house.
Okay.
They in turn loaded another mattress from Suzanne's house,
Right.
and then returned to Ronald's residence.
Okay.
And at Ronald's residence, after that is when the accident occurred.
Okay. Now, does the evidence in the light most favorable to the plaintiff suggest that they made a direct trip from Suzanne's house to Ronald's house?
Yes, Your Honor.
Okay. All right. Now, is there an inference that can be drawn in the record that when they arrived at Suzanne's house, both of the brothers were in the car?
We don't think there's a reasonable inference that can be drawn. There could be, if you place the affidavit of Suzanne Hudak under a microscope and looked at it that way, then possibly there's an inference.
Well, is it reasonable that is it a reasonable inference that when they went to Suzanne's house, they went in the same car?
Well, not if you look at all the evidence. The evidence being Suzanne Hudec's previous deposition testimony wherein she said she wasn't looking for her husband's car, and then coupled with the deposition testimony of Ralph Hudec, who says at no time was his brother ever in his car.
Well, I know you've got direct evidence from Ralph, but I'm searching for the inference that the plaintiff is arguing here. Is it when Suzanne says that when they arrived, I didn't see, I only saw one car, and I saw them walking up together. I don't remember exactly what she said. Isn't there some inference that they came in the same car that can be reasonably drawn from just her testimony, viewing her testimony without regard to what Ralph said?
Well, I think if that's the way we're to view it under this microscope, without taking into account all the other evidence, then there would be an inference that they possibly could have driven in together. Other inferences being...
Right, and from that inference, can we also draw a reasonable inference that if they arrived there together, they left together and arrived at Ronald's house together?
I don't think that inference has been made, but I would think a stacking of inferences in this case, that is what you would have to do. You would have to stack inferences one on top of another.
I thought you told me earlier that they left Suzanne's house and they went directly to Ronald's house. Maybe I'm mixing the brothers up, but in other words, there wasn't any break in the action there. They left Suzanne's house and they drove directly to the other house. Right?
Correct. Okay. In separate vehicles.
Well, according to Ralph, but I'm still working from the inference in her. If it's a reasonable inference that they arrived at Suzanne's house in the same vehicle, looking at Suzanne's affidavit, is it also not a reasonable inference that they left in the same vehicle and arrived at the next residence in the same vehicle?
I guess it would be reasonable if you were looking strictly just at her affidavit.
Okay. Assuming that there is that reasonable inference, is that sufficient to avoid summary judgment if we assume that when he got there, he alighted from the car, unloaded the mattress, and then went to help him back the car out of the driveway?
Oh, of course not.
Okay, why not?
Well, because the alighting ceased once he got out of the car and brought the mattress into the house. The process was, assuming that they arrived together back at Ronald's house, they got out of the car, they unloaded the mattress, they brought the mattress back into the house.
The record's clear that the mattress had been unloaded.
Correct. The record is clear on that. The record is also clear that they returned and exited the house. At that point, the moving for the day had ended. They were done moving. Ralph Hudec, the record is clear, was late to meet his wife for a social engagement at a church. He said, "I need to leave." Ronald said, "Let me help you back out. I'll direct traffic." Ralph said, No, I don't need your help." But Ronald decided to do this anyway. It's at this point when Ralph attempted to back out and he was struck. And what I was getting at the beginning to Judge Thompson.
You understand what he plans to do?
Pardon me?
My question is, if he's at home, his brother's leaving, Mr. Martucci states that he was in the process of getting out, and I assume he was saying that he was getting back in, but from the record it appears he was home and planning to stay home.
Correct. That's correct. Ralph Hudec was leaving to go to a church engagement with his wife.
Is there anything in the record distance between the vehicle and where Ronald was struck?
Well, that's what I was going to get at. At the record on page 386, which is the deposition testimony of Ralph Hudec, he says he was nowhere near his vehicle when he was hit. That's what's within the record. At the time he was struck by the vehicle, he was nowhere near his vehicle. Your Honor, the only reasonable inference that can be drawn from Suzanne Hudec and her testimony is that she simply did not see her husband's car, and that was because she wasn't looking for it. Now, the appellant is choosing to take one piece of evidence, this affidavit, instead of Suzanne Hudec's deposition and Ralph Hudec's testimony in an attempt to create a reasonable inference. And clearly, this is not a reasonable inference, and it's clearly in conflict with undisputed testimony, specifically the deposition testimony of Ralph HUDEC. As such, for this alone, the trial court's order granting summary judgment should be affirmed. And then, assuming for argument's sake, as we were discussing, that Ronald HUDEC was occupying Ralph HUDEC's car upon arriving home to drop off the last mattress, he still couldn't be occupying the vehicle. They arrived back at the house, they removed the mattress, they then exit the house after placing the mattress within Ronald's house. The moving was complete. Ralph got back into his car to leave. Ron offered to assist with backing him up. Ralph refused the assistance, and as Ralph began backing up, Ron was struck and killed by another vehicle. He was clearly not alighting from the vehicle at the time of the accident. Therefore, he was clearly not occupying the vehicle at the time of the accident. If he had the occupied the vehicle at all, if taking the evidence in light most favorable to the appellant, the occupancy clearly ended prior to the accident. Thank you.
May it please the court, I would just, I'm not going to take all my time, simply reiterate the fact that while Judge Jacobus did indicate that whether or not Ronald HUDEC had driven over with his brother was not controlling, the controlling issue was as to whether or not Ronald HUDEC at the time of the accident was in the process of alighting from the vehicle. And as I indicate, the case law, if the court accepts the case law of our sister states as well as the sister districts, Tanchuk, Day versus Coca-Cola, the Asnet case in Florida, the Century Insurance Company case from Wisconsin, and all of the abundant case law on the subject. Olson creates the zone of risk question, and the question of whether or not the task had been completed that the HUDEC brothers had undertaken at the time of the injuries which unfortunately resulted in the untimely death of Ronald HUDEC at some 43 years of age, leaving a 10-year-old child. I just believe that the trial judge did not follow the rules of Hall versus Talcott in questions of summary judgment. I'm sure the court members are familiar with Hall versus Talcott and the other case law, and I just respectfully request that this court reverse Judge Jacobus' order on summary judgment and send it back for a jury trial in order that the jury be able to resolve those issues. There is a difference between the definition of policy coverage, which is a matter of law, and the question of the facts which give rise to the need for the policy provision to be construed, and the latter being a factual issue for a jury to determine. Thank you, Your Honor.
Thank you, sir. Thank you, David.